So, in this video I would like to talk about the various preventive detention laws which were enacted in the country and what are the issues related to that. So, preventive detention laws are an exception to Article 22, and Article 22 is about your rights during arrest. But throughout the history, even before independence, we had many preventive detention, at least a couple of preventive detention laws were there. So, I would like to talk about the various preventive detention laws. So, if you look at the history, in fact, during the British time, right in 1818, 200 years before, during the British time, there is a Bengal Regulation 3. Bengal Regulation 3rd, and in this also government is empowered to detain anybody on mere suspicion. So, 1818 there is a provision for, in the Bengal Regulation 3rd, there was a provision for detention on any suspicion. Similarly, in the Defence of India Act 1939 during the Second World War, Defence of India, see it is, at least we can say it is during the war, in a Defence of India Act 1939, Rule 26 had provisions. Of course, it is a wartime legislation, allowed detention of a person. So, preventive detention was allowed. But as I was mentioning earlier also, in normal course of things, preventive detention laws should have lapsed after the India attained independence, and it is a British law. There were no fundamental rights at that time. So, preventive detention laws are justified. But the framers of Constitution decided to retain the preventive detention laws as a means to curb anti-national activity. The logic, the argument in the Constituent Assembly, the logic in the Constituent Assembly was that for maintaining or rather controlling the anti-national activity, to prevent anti-national activities, we need preventive detention laws. So, that is how the first Preventive Detention Act was passed in 1950. The Preventive Detention Act was passed in 1950. So, Preventive Detention Act of 1950. Then after its expiry in 1969, also once it was there for almost 20 years, then it was passed in 1971, the Maintenance of Internal Security Act. (1971). So, this, or it was also known as, the short form was MISA. The Maintenance of Internal Security Act, MISA, was enacted. One funny anecdote I would like to add here. The Lalu Prasad Yadav, the former Chief Minister of Bihar, he was arrested in this MISA Act, and he has said in many times later on also, during his arrest, or when he was arrested and he was in jail, his wife gave birth to his first child, and he named her as Misa. That is what he told subsequently. Anyway, that is a, I will say a small joke in between. So, because he said, since he was the Misa word, then he was arrested under Misa, so he named his first daughter as Misa, because he was in jail at that time when Rabri Devi gave birth to their first child. Okay, anyway, so that was this. Then subsequently another an act was passed in 1974, a preventive detention, that is an economic adjunct called coffee posa. Conservation of foreign, the full form of coffee posa is, in 1974, the full form is conservation of foreign exchange. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, and Prevention of Smuggling Activities Act. So, you can see that COFEPOSA. Okay. So, prevention of foreign exchange, conservation of foreign exchange and prevention of smuggling activities act 1974. Then subsequently the draconian laws came in 1980s during the time of the the militancy in Punjab as well as in Jammu and Kashmir when it has begun. Is that TADA was passed. TADA in 1985. Terrorist and Disruptive Activities Prevention Act. TADA, the Terrorism and Disruptive Activities Prevention Act. Terrorism and Disruptive Activities Prevention Act. That is why again TADA. Okay. TA, Terrorism and Disruptive Activities Prevention Act 1985. And it is one of the most controversial law in our country, we can say, under which many people were arrested, many innocents were arrested, and I will just talk about that a bit. And then subsequently, once this TADA was withdrawn, once it was in 1990s, in 2002, when during the NDA government's time, POTA was passed, POTA, Prevention of Terrorism Act. Prevention of Terrorism Activities Act. So, that is the POTA, Prevention of Terrorism Activities Act. So, that was in 2002. Subsequent, see both these laws, all these laws, whether it is a MISA, this TADA, POTA, all of them are withdrawn subsequently. MISA, TADA, POTA, all these have been withdrawn subsequently, but COFEPOSA is still there. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act is still in force, but MISA, TADA, POTA, etc. have been withdrawn, and subsequently another in a big act, then the National Security Act was passed. I mean, that is one. Then National Security Act in 1980. National Security Act 1980 was passed subsequently, I mean not subsequently, during this time only. There is another act which can be said. Then there is also Prevention of Black Marketing and Maintenance of Essential Commodities Act 1980. So, these are also having some preventive detention provisions. Prevention of Black Marketing and Maintenance of Essential Commodities Act. Maintenance of Essential Commodities Act. These are also, I mean 1980 again, these also have some of the provisions for preventive detention. But right now, then subsequently, what has happened is there was an UAPA, I will come to that separately, Unlawful Activities Prevention Act 1967, various amendments have been made, now it has become quite draconian. Not only this, we had a MCOCA, in various state governments have passed such laws. Maharashtra Control of Organized Crimes Act. Maharashtra Control of Organized Crimes Act. So, like this, many such laws were passed. So, there are many preventive detention laws in our country, and as I told you, TADA and POTA were the most draconian, and both have been withdrawn now. But UAPA then Sedition Act. So, there are many provisions in our country which can ultimately lead to this kind of detention. These draconian laws, the biggest problem is if proper safeguards are not there, and in a country like India where so many poor people are there, so many illiterates are there, and where so many people who are not even aware that there are fundamental rights, proper safeguards are not going to happen. So, coming to the analysis of such preventive detention laws, coming to the analysis, in the absence of proper safeguards. See, safeguards can be there only when the people are aware and people have they know about their rights and also they have the capacity to fight. Then only the safeguards will come. These preventive detention laws are grossly misused. And particularly if you look at the victims, particularly the Dalits, the tribals, yes, and in many cases the Muslim minorities. See, I am specifically talking about Muslims because the problem in our country is the Muslim community are also socially and educationally backward. And they are always looked at with suspicion because of the activities of Pakistan, Bangladesh, and so many things. We know very well how difficult for a minority in a country like India to survive, and they are always, and we will be talking about the minority issues, and even Sachar committee I will be talking about in some other video about the problems faced by them, especially the Muslim community in our country. So there are, if you look at these laws and the kind of people who are arrested and sent to jail, you will find that a vast majority of the people who are booked under such preventive detention laws are either Dalits, tribals, minorities, especially the Muslim community. So the chance of misuse is very, very high. And let me just remind you, this TADA, which was there from 1985 to 1997, almost 76,000 cases were there. And it was found that, now 2-3 things about TADA I would like to say, because these are well documented cases in TADA. It was found that even though the TADA case, there were 2-3 allegations about TADA, or some of the facts which you have found is, TADA was enacted when the terrorist activities were maximum in Punjab and in Jammu and Kashmir, or other the secessionist activities were there. But it was found that maximum number of cases were recorded in Maharashtra and even in Gujarat, where there were no terrorist activities. So even though it was for terrorists in 1980s in those regions, but ultimately maximum number of cases were recorded in Maharashtra and Gujarat. And in most of the states where there is a disproportionately high number of Muslims, the minorities under arrest under TADA, in Rajasthan and all, it was found that more than 90% of even though the population of in Rajasthan, the number of Muslims in Rajasthan are so less, but more than 90% of the accused in the TADA cases were Muslims. Then another very interesting thing, I said 76,000 cases were there, and finally after sending, and there were a provision in the TADA that an accused can be kept in police custody for 3 months, 90 days. And it was found that ultimately 74,500 plus cases, they were all acquitted. Finally, the prosecution could not prove the case. The prosecution could not prove the case. Prosecution could not prove. So these innocents, the 74,500 people were ultimately turned out to be innocents out of the 76,000. Just imagine. So the conviction rate is so low, and the meaning, the conclusion what we can make is, in most of these cases, these people were arrested and sent to jail on false pretext, misuse of the law. In fact, in Maharashtra, it was found that even pickpockets, yeah, even student activists, women activists, or there are so many people in a society. We can see there are many people who are a pain and who are a headache to the police, also the administration also, who will come and complain on everything and anything. You can see this nagging people, the people who know some law, some provision, and then they will go and complain and create trouble everywhere. I mean, it's a nuisance. Even such people who created nuisance, even such people are arrested and sent to jail under TADA in Maharashtra and Gujarat and all. So there were so many cases of misuse. See, now my argument here is very simple. Any preventive detention law in India, the problem is the chance of misuse, and we have found that, see, if it is used against terrorists, there is no problem. See, we are not I am not arguing for the rights, the human rights of the terrorists. But in the name of terrorism and terrorists and national security, if you are sending innocents to jail, if you are sending student activists to jail, if you are sending, women activists to jail, or even the local, small-time criminals, small-time petty criminals, small-time petty politicians, if they are sent to jail only to settle the scores, political scores, under Tada and Pota, if it is there. See, immediately I can just remember, you might have heard about the Kerala gold smuggling case. Now, it's a gold smuggling case, 100% sure it's a smuggling activity. But they were all booked under UAPA, Unlawful Activities Prevention Act, where they cannot get a bail for next 90 days. Just see, now it's a pure case of gold smuggling. Now, you can always say that there could be a national security angle. Anybody can say this for any activity. If there is a road accident also, you can say that, oh, there is a possible, there could be an angle of national security involved in, there could be a design, there could be a conspiracy. Anybody can say anything. So the problem is, this can be misused very easily. And when the misuse happens, it is always, see, many a times we support such laws, saying that it is not affecting me, or it is affecting only those who are criminals. See, but that is not the case. There are so many instances in our country, and hundreds of instances, not why so many, thousands of instances where innocents are framed under one or other draconian law. So the problem in our country, some people may say that similar laws are there even in US also, maybe in the terrorists and all, like Tada or Pota, such laws are there in US. It is agreed, but US society, their education, even then, even in US, you might have seen the Black Lives Matter, the way the civil rights movement are going on in US, the black community, the way they are fighting. You can see even in US, where there is so much of education, so much of awareness, even a black community have much more education than our Dalits, our tribals and our minorities, especially the Muslim community. If they are suffering, and the way, the high-handedness with which the American police is behaving on the black community, you can imagine what is the situation of our poor people, the illiterate, the Dalits, the minorities. So that is why, in the name of national security also, if these laws are taking away the liberty of the people, the rights of the people, we need to restrain. There should be mechanism to minimize such laws. And if at all such laws are there, there should be extensive provisions for, protecting the rights of the innocent people. So my only argument here is, any draconian law, any such law where the police is given extra rights or extra power and extra authority, where the police can bypass the normal legal procedure, this can result in a violation of the rights of the people. And all the preventive detention laws, all such detention laws, especially the Tada, Pota, UAPA, all of them, the chance of misuse is very, very high, and it is very difficult to control it. So this has to be, in a democratic society, in a modern society, in a liberal society, where we are talking about liberty and liberalism is the philosophy of should be the society. A modern liberal society cannot afford to have such laws. We need to fight, and we have to stand in unison for the rights of the people, and then only, our society, our Indian society can be truly democratic. So that is where the preventive detention laws are standing. Many laws were passed. I will be talking about the UAPA separately, because even an amendment was there recently, and it has made all the more draconian right now, which is not the right way in a country like India, which is such a diversity, such a vast diversity, and such a large population, where so many people are illiterate and poor, and they have no means to defend themselves. These draconian laws can easily be misused, and it is being misused in our country, and it is a sad part of our democracy. Even after 70 years, we are not able to plug all these loopholes in the system. So all preventive detention laws, the chance of misuse is very high. That is the final conclusion from my side.